Hey there, it's Kathy, and you are probably in the middle of reading Module 2, somewhere in week 4. And I wanted to talk to you this week about all the different employment laws. So I'm sure when you read half of Module 2, you were like, holy cow, I didn't know there was this many laws. And I think they can get very confusing because we as HR practitioners, we've had the support of legal counsel, whether it's in-house or outside, typically when we have questions around these. And so what I want to do today is just go through and summarize each one of the laws and talk about the important points and clarify some of the different characteristics within the laws. I think in general, if you think about the laws, the way I understand them and the way I remember them is by putting the laws in context. In other words, what was going on in our country, in our environment, in our economy that necessitated this type of law. So the first one obviously is very easy. If you think about Title VII, the Civil Rights Act of 64, we all know what was going on in the 60s in this country with the race relations, with women coming into the workplace for the first time, in numbers, not the first time, but the first time in numbers. And so if you think about what was going on in the workplace, um, there was discriminatory practices against minorities, those that were not white males, because white males have been typically in the workplace. So if you read through the slides, I think the very first one talked about the protected classes, and at the bottom of that slide it said there are 10 federally protected classes, and it never did go into the detail among that. And if you're like me, I like the detail because I want to know what are the 10 federally protected classes. Now they stretch through different laws. They're not all a part of Title VII. That's probably why they didn't list them all there, in fear that it may confuse you. But let me run through those real fast. Race, color, religion, national origin, age, sex, pregnancy, disability, veterans, and then citizenship as it relates to the I-9. So those are the 10 categories. So back to Title VII, 1964, a very chaotic time for this country, lots of going on with our race relations, women coming into the workforce. We had the Vietnam War, so there was just lots and lots of things going on. And then when our vets came back, just like the vets that are returning now, it's hard for them to get a job, especially during those times because obviously Vietnam was not one of the more popular wars, so those veterans were not greeted sometimes with the respect they should have. So Title VII passed in 64, and it protects against race, color, religion, sex, and national origin in the workplace as it relates to not just hiring, promotions, access to training, all that sort of thing. So it's not just one activity. We think it's all about hiring, but it's not. It's any decision in the employment process where that you might use a discriminatory reason for not allowing that person to be promoted, to get a rate increase, to participate in some training, or some different opportunity. So those are the different classes. Now, I get the question a lot, what's the difference between race and what's the difference between color? And so race, we have African American, we have Asian, we have Hispanic, we have Caucasian, but within some of those races, within Hispanic, within African American, there's different variations of skin colors. And so within the race, there could be discrimination in regards to one's skin color being lighter versus darker. So that's the delineation there. So I wanted to bring that up as well. And so I think the book did a really good job of all the terminology. I think we hear a lot of it. Sex, how do you define sex? And that's just classifying people as male or female. And it's your biological determination, what makes you male or female, because there's so much talk now about your sexual orientation as being a protected class, and it is in some states. For Georgia, it is not. But the test does not cover, just so you know, if you didn't read that in your book, it's like on the first page of Module 1. The test does not bring in any state-related laws regarding these statutes. So it's only the federal laws that you'll be tested on. And then gender. I thought the definition for gender was quite interesting. It's the socially constructed roles, behaviors, activities, and attributes that a given society considers appropriate for men and women. So the gender is more societal. Then transgender, if birth assigned sex and internal sense of gender identity do not match, that would be transgender. And then, of course, national origin, country of one's birth. And so we just want to make sure as HR professionals that our policies and our practices, whether intentional or not, and we'll be talking about that in just a minute, that they do not result in discriminatory practices. And another area that we have to be very careful of is with our managers, because they don't know what they don't know. And so, management training in this area is so important. Especially with our new managers, because some of these HR laws are very complex to managers, and it may be the first time that they were exposed to some of these. So besides the protected classes, Title VII makes it unlawful to deny employment opportunities for training, career advancement, like we talked about. It also prohibits sexual harassment, and I'm going to stop right there for a second and talk about sexual harassment, because there's two types of sexual harassment. So it could be quid pro quo, which is this for that. And typically it's a person that has the perception of power, rather by role, job description, whatever, over a subordinate, and they ask for a sexual favor in order to get favorable treatment in the workplace. This type of sexual harassment, the quid pro quo, Latin for this for that, is definitely the hardest one to prove, because typically, this type of harassment doesn't occur right out in the open. So it's usually someone's word against another person's word. So that's when HR has to intervene and really start that investigation process as quick as possible to make sure that those stories are fresh in everybody's mind. So that's one, quid pro quo. And then we have hostile work environment, which typically is more prevalent. And actually, I think it's more prevalent because, again, people don't know what is appropriate at work and what is not. You would think that, forwarding jokes of a sexual or racial nature would be common sense, but, some people are not offended that way. And so they, as you guys have probably been a witness to in your own organizations, those emails get forwarded and they're offensive. And, they're a permanent record. Those emails, even though you delete them or ask people not to send them, they're still part of the public record. Well, not public record, but they are discoverable. And so you want to keep your workplace free from these type of distractions, especially because you think about the reasonable person standard, and that's what a lot of the case law uses. As a reasonable person, while they're working, really would find racial content and sexual content offensive at work. So when that sort of thing happens, it can create a hostile work environment, especially if you have managers that are cursing or being very loud or yelling, slamming doors, and just making the workplace just very hostile and intolerable. So we need to train our managers on these behaviors and making sure that when these issues are brought forward to us as HR professionals, that we act quickly, because those can really spin out of control very quickly. So there's some exceptions to every rule, right? So Title VII has a few exceptions we want to talk about. And they seem to love these on the test to give you a scenario that directly points to one of these exceptions, and you have to identify what it is. So let's go through those really quick. So first of all, we have a work-related requirement. A work-related requirement for that job. And that's very similar to a BFOQ, bona fide occupational qualification. So thinking about, the book does great with the examples. So thinking about a male bathroom attendant for the men's restroom. The bona fide occupational qualification would be you'd have to be a male to be in that restroom. Or a lady modeling lady swimwear. Bona fide occupational qualification. So those definitely would necessitate either a male or a female for that position. Now, I don't know if you guys remembered, it was probably 10 years ago, the big Hooters case. There was a male that actually applied to be a Hooters girl, and because of their brand, they were able to get a BFOQ, bona fide occupation qualification, that to be a Hooters girl, because it was a big part of the brand, that being a woman waitress, a female waitress, was a BFOQ. So that turned out to be pretty interesting, I thought. Negotiated seniority system. So if you have a explicit seniority system that says you are promoted after 1 year, 2 years, and typically you find these in the union environment, but that would be an exception, because if all of the people that had been there that length of time happened to be from one race or one age, then because you had that seniority system, it was set in stone and they would be promoted. And then, of course, affirmative action plans. We do have and we'll be talking about that soon at the end of this discussion. Affirmative action plans takes a look at our landscape and looks at what's on the outside of the environment and what does that population look like, and what do we look like on the inside, and is there any imbalance, and if so, what are we going to do about that? And that's what the affirmative action plans are for. And so there could be some hiring around that to get our numbers up. So there could be some exceptions, and we can point to affirmative action plans. Now, I'm not saying hiring people, we always want to hire the most qualified candidate, don't we? Or the person that matches. You have to be careful with this wording sometimes. The person that meets those job descriptions, because sometimes you can be overqualified, can't you? So it's not really about the most qualified. It's the person that meets those standards and the knowledge, skills, and abilities on that job description. So hopefully that give you a little delineation about the exceptions to the rule, because I do find that question is a favorite amongst the tests that I've seen and the ones that I've heard from former students. So then in 1991, there was some teeth put into the Civil Rights Act. Basically, it allows jury trials, and it set damages. And in the book, it gave you the chart and the damages based on number of employees. So if you have 500 or more employees, you could be subject to a $300,000 penalty. And so, and you multiply that by how many instances, if you've discriminated across a whole class of individuals. That's why you hear about all these class action lawsuits. So you want to be very careful. And mostly what I say about these things is you want to do the right thing. I mean, it's, we do have these laws, and we want to make sure that we are following these laws, and that our policies and practices follow these laws. But we also want to make sure that we're treating everyone in the workplace with respect that they deserve. And so, thinking about doing the right thing, and in some of these instances as well. So then we're going to talk about the age discrimination. So this is where this came in 1967. Now, I will tell you that the years of these laws are not important. They don't ask you about years on the test, but again, remember when I opened up, it's really important to set the context. So the initials they use for this piece of legislation is ADEA, and it's the Age Discrimination in Employment Act, and that was in 67. And so you think about what was going on to necessitate this type of law. So, it was the younger generation, just like what's happening now with us. Things sometimes just happen in cycles, don't they? The younger generation was coming in. They were cheaper. So who did they get rid of? The folks that were making the most money. They were the older folks. So that's why we have the ADEA. And it prohibits employment discrimination against persons over 40. That used to sound so old to me. It prohibits mandatory retirement based on age, and it limits employee status due to their age. You can't do that. It covers employers with 20 or more employees, unions with 25 or more members, and employment agencies and apprenticeship programs. So I will have to tell you that with these laws, because the ADEA, the FMLA, all of these have different coverages of employees. One covers 20, 25, whatever it may be. You're just going to have to memorize those. And I don't know the rhyme or reason for how they did it. I wish they were all the same because it would make our job a lot easier. You're just going to have to memorize those. And of course, again, every rule has its exception, and the ADEA exceptions are age could be a BFOQ. Remember what a BFOQ is: bona fide occupation qualification. And if it inhibits the normal operation of the business, think about this. Typically may happen in the airline industry with pilots. They get to a certain age, and if they do not have, correctable vision, that could be an issue there. Exceptions can occur if you have a genuine seniority system, like we talked about earlier. The employer has disciplined for good cause and good reason. Then, of course, you can fire anybody of any age. That is always a great defense, by the way. If you fire for good cause and not a discriminatory cause, and you've done your due diligence in your progressive disciplinary policy, you followed that, then that's a great defense, no matter the age, the race, the color, the gender, anything. So the employee, another exception is if the employee is a top executive policy maker. You could see the impact if somebody's if they're older and they're not making as good of decisions as they once were, then something would have to be done for the good of the company. So that's ADEA, and then we have Pregnancy Discrimination Act of 78, where it says you can't refuse to hire or fire a woman simply because she's pregnant. You can't force a pregnant woman to leave their job if they're not, if she's ready, willing, and able to do the work, and the doctor says she can. And then the big piece of this is that pregnancy was treated just as any other temporary disability. So that meant that pregnant women could use their short-term disability and have leaves that could take care of children and have that baby. So that was big. The next one I want to talk about is the ADA. Is this enough letters for you already? And we've only been talking about 20 minutes. Americans with Disabilities Act, and that was 1990. I believe that was President Bill Clinton, if I remember correctly. And again, it prohibits discrimination against qualified individuals with disabilities. And then it requires reasonable accommodation unless the employer can show undue hardship. We'll be talking about that in just a second. And again, here's the coverage. It applies to employers with 15 or more employees, employment agencies, labor organizations, and joint labor management committees. And so here's a couple of terms for the ADA, and that's disability. He has an impairment that substantially limits one or more major life activities, breathing, walking, hearing, things like that. Has a record of such impairment and is regarded as having that impairment. And then the essential functions is a really critical theory in this piece of legislation, because what it says is The primary job duties that an individual must be able to perform with or without a combination. And those are the essential job functions. And that points back to why it's so important that we have job descriptions that go into detail around some of these more physical activities. So we give job descriptions such a bad rap, and you're getting ready to read about, or you might have already read about, job analysis, and the end product of the job analysis is the job descriptions that have the specifications, the knowledge, skills, and abilities. Because if there's ever any question about hiring of a person with disability and essential job functions, the first piece of evidence they're going to look at is the job description. And so that's why it's critically important that you list things like squatting, standing, lifting, bending, walking, all those physical things of the job, and so that it's clearly spelled out, so that, when we have these situations, obviously this law was designed to get the disabled back to work. And again, we want to do the right thing. We want to treat everyone with respect. So if this person can do those essential functions of the job, great, let's hire them. Now, the second piece of this is what we call as reasonable accommodations. So we've got our job description. We found out that our candidate that is in a wheelchair, they have the essential functions. They can do the job. Now that gets to reasonable accommodation. Is it that they need a wider desk so their wheelchair can fit in under the desk? Is that a reasonable accommodation? Probably so. Even with a small company, you can buy a desk at Staples for relatively cheap. So those are the sort of considerations you have to think about. The ADA has, just like with Title VII, has a few amendments. It retains the basic definition of disability contained in ADA, but expands the interpretation so it was easier to qualify. It makes it easier to meet the definition of disability. Includes 9 rules of construction. Identifies several impairments that virtually always meet the definition of disability. And then expands the ADA's list of major life activities. And all those, I won't go through all of those, but they are definitely listed in your book. So the ADAA, that just put teeth into the original act of 1990. So those are our first two. Now let's talk about GINA. I don't know if many of you have heard about GINA, but excuse me, let me turn that off. Sorry about that. GINA stands for Genetic Information Non-Discrimination Act, and it was passed in 2008, and it was kind of funny because everybody was like, what is this about, and why did we pass this piece of legislation? And what it says is it prohibits discrimination against an individual in hiring, firing, or compensation, or terms or privileges of employment on the basis of genetic information about the individual or family member. And when you dig deeper and look into it, it's because, we may require a medical exam for a position that's relevant, that's job related, so we require a medical exam. And in that exam, the questions like, did your mother have cancer? Did your father have diabetes? All those sort of things. And if that reach back to the employer may think that you may have the propensity to have those diseases, or perhaps you did have a genetic test in the course of employment, and the employer inadvertently found that out, and there was some discrimination because they felt like that you have the propensity to have breast cancer, you wouldn't be around to take a management position or what have you. So GINA is relatively new. Lilly Ledbetter, that one was so interesting. I believe she has written a book about her experience. It was very interesting case. It was Ledbetter versus Goodyear Tire and Rubber. She was an employee there for a long period of time. She was not making the same amount of money as her male co-workers. Her performance, and I believe it was the same or better But there was hardly any variation in performance between her and her male counterparts. So she sued and she took it as far as she could. And basically, she won. And what it said is when we have a discriminatory act, such as a pay increase or a merit increase that's discriminatory in nature, then each time that transaction happens, say a payroll check, then it creates a rolling or open time frame. So every time that paycheck hits, the clock starts ticking again um, on the time frame on which you can open a case. So the statute of limitations just keeps on with every paycheck. And so again, the impact of that legislation is, you've got to really be sure when you're looking at pay increases, merit increases, promotions, that you really have some rationale behind it. Better performance is a great rationale, but making sure that our performance documentation expresses that or mirrors that, because I think what we've done in performance management is gone down the path of least resistance, which is, everybody's a 3 and there's a few people that are 4s and fewer that are 5s. And so it's very hard to differentiate the variation in performance, but yet people get various different pay increases, so they don't match up sometimes. Hopefully that made sense. And so that was the impact of the Lilly Ledbetter Act. Very interesting book. The case went on for many, many years. Let's see. Let's look at, see what else we need to talk about. There's so many, right? Let's take a look at what I want to discuss now is adverse impact. I'm sure you read about that. And disparate treatment, adverse or disparate impact, and perpetuating past discrimination. Now, these are going to be very, very important because they're concepts that really get to proving if we have discriminatory practice or we do not. So these are the tests we're going to be using. And so you had some examples of the book on how to look at adverse impact, the 80-20 rule, and I suggest that you guys be very familiar and be able to calculate that. There was an example in the book. There's an example on the PowerPoint presentations. So if you're having any issues with that, please let me know and we can detail that over a conference call that we'll be having, or we can try to explain that in a forum, or you can call me, but be sure you understand that. So adverse or disparate impact applies rules that have negative impacts on protected classes to all employees. So that is something that we want to make sure that we look at, and we make sure we stop that practice if it's having a negative impact. Now, disparate treatment is treating protected classes differently than other employees or evaluating them by different standards. Now, disparate treatment is typically intentional, whereas adverse or disparate impact can be intentional or non-intentional. So, but when you're treating somebody differently, that's pretty much intentional. And then perpetuating past discrimination is using employee referral programs that maintain racial inequity. Because if you think about referral programs, who do you typically refer? You refer to people that look like you, hang out with you, and so that may perpetuate past discrimination because we keep hiring the same class of person. Hopefully that makes sense. And so again, what you need to look at is that 80-20 rule, making sure you understand the adverse impact. Then you probably noticed that there was several key cases that were in this section, and I would, they do a good job of giving you a little synopsis of each case, and that's about all that you would need. But I would definitely make sure Griggs versus Duke Power was the big adverse impact case. The McDonnell Douglas versus Green, which was the disparate treatment case, know that one. Other key cases, the Albemarle paper versus Moody, Washington versus Davis, St. Mary's versus Hicks, and McKinnon versus the Nashville Banner. So knowing all those, again, with cases, they don't ask the year as well. So hopefully that'll help you as well. So now we're up to EEO reporting and the affirmative actions. So we're going to go through those two concepts. EEO reporting is an annual report that employers with 100 or more employees and federal contractors with at least 50 employees and a contract of 50,000. So that's pretty wide sweeping. So most of my clients and most of the employers I've worked for have had to do an EEO report. And so they're due every year by September 30th. Your posters have to be put out and displayed, typically in the break room. And typically what we're doing as far as EEO reporting is we're looking at our workforce, and we are, it's a snapshot in time, and we're looking at it by different job grades, all the categories that we talked about earlier, men, women, race, all that sort of thing, and reporting on that in time. And so what it's designed to do is making sure that we are cognizant about, who we're hiring and who's in, positions, leadership positions, and all that sort of thing. And so where we get into action around that is in the affirmative action plan. So a lot of people get a little confused with this. So the EEO-1 report is a report, for the government. They want to have a snapshot of what the workforce looks like, and we can contrast that with the affirmative action plan, which digs a little deeper. And what it does is, okay, here's the snapshot, and we also want to look at the workforce analysis and where the gaps are and what we plan to do about that. So not only is our snapshot by getting pretty granular around race and title and location and things like that, but it's okay, well, the outside demographic looks like this and the inside looks like this. We've got a delta of this. What is our plan to close that delta? And that's what we need to do. And so in general, it's to make efforts to increase presence of women, minorities, covered vets, and disabled individuals in the workplace. And it like I said, it takes steps to correct further underutilization. So we know we've got a situation maybe with hiring the disabled and vets. We don't want to continue that, but how are we going to close those gaps? And so you also look at the availability analysis on that. In other words, what does the outside look like? And you can usually get that from maybe the chambers of commerce and things like that. But there's some analysis that goes on with that. So those two reports are looking at the organization, looking at its demographics, and looking at a snapshot in time. And specifically, the affirmative action plan is, what are you going to do about gaps? What is your plan? I'm going to target Hispanics. We are 10% low in our applicant pools and our hiring on Hispanics. We're going to go to the Hispanic Chamber of Commerce. We're going to, X, Y, and Z. We're going to hire Hispanic recruiter that's bilingual. Whatever we're going to do that says that we're going to take action on that. So I think that covers the highlights of those, the laws that were in the first part of Module 2. I know that there's many of them, and I know that they can be quite overwhelming, but again, keep them in context. Memorize the coverages, in other words, the number of employees that law applies to. There is a good resource online. It is a handout that details all the different laws in one place, and I think you'll find that very helpful for you as well as a study guide. So good luck this week, and I'll be talking to you very soon.